What's going on, you guys? My name is Rafael Jemerson. I'm with Stamper Signings. We're a nationwide notary service that specializes in notarizing estate planning documents. We serve as estate planning law firms, and we also service title companies all across the nation. So in today's video, we're going to talk about how to notarize Georgia estate planning documents. This will be the first of many videos to come. We will be doing a document review series where the goal is to upload document review videos for estate planning documents in all 50 states. So what compelled me, excuse me, what compelled me to do this, to pretty much do this document series is typically when we're working with newer notaries, um, newer notaries don't really have a ton of experience with notarizing estate planning documents. So when we do work with new notaries who are not familiar with notarizing these type of documents, there tend to be mistakes, and we typically have to have notaries go out to get those corrections made, whether it's a missignature, whether it's a misinitial, or maybe they're just a misunderstanding in the instructions with getting these documents signed. So we're going to start off with Georgia. If you're a Georgia notary that's watching this video today, please make sure you review this video, take plenty of notes. We're going to do our best to make sure we cover as many documents as you're going to see in a typical estate plan. So for your estate plan documents, they're typically pretty common. You're always going to see either a deed, either going to see a quitclaim deed or a grant deed. You'll see assignment of personal property. You'll see a certification of trust. You'll see a will, or it could be a last will and testament, depending on what state you're in. You will see a revocable trust document or a living trust document. But those are the pretty common documents that you're typically going to see in the estate plan. So the first document that we're going to start off with is the quitclaim deed. Now, the quitclaim deed is a document that we normally get questions about. Typically, the question would be: is the signer is transferring their name into the trust? They want to know if this is acceptable. So this is pretty much what the quitclaim is. So let's say, for example, I'm Rafael Jemerson. When I purchased the property, I took on title of the property as Rafael Jemerson. Now let's say that I have this property, it's in my personal name, but I'm setting up my estate plan, and the name of my trust is called the Rafael Jemerson Living Trust. What I'm going to do is I'm going to transfer title of my property into my trust. So I'm quitting claim of the property, and I'm granting the property to my trust. So normally what you'll see Rafael Jemerson. Rafael Jemerson is granting the deed to the Rafael Jemerson Living Trust. And the Rafael Jemerson Living Trust is the grantee. So I'm releasing the title of the property in my personal name, and it's going into my trust. So typically that normally confuses notaries because when they look at the documents, they're like, well, why is this person is signing? Why is the person quit claiming the deed from he's pretty much quit claiming the property. He's pretty much granting the property from himself to himself, when in actuality, they're not. The person's actually granting the property from themselves into their trust. So it can sound, I hope that doesn't sound confusing. If it does, make sure you rewind this video again, and I'm pretty sure it's going to click for you. So this is typically what you're going to see in an estate plan. You're going to see either a quitclaim deed, or you may see a grant deed to a revocable trust. You're pretty much going to see where that person is transferring property from themselves. They're granting they're the grantor, and they're granting the property to their trust. So hopefully you guys understand that. That is typically what you're going to see in your typical estate plan. And the quitclaim deed will always need to be notarized. Okay. So next we have the power of attorney. For this power of attorney in Georgia is going to be formatted differently than you will see in California and other states. First off, it starts off with the designation of agent. So for this principle, The principal is designating the property, is designating a specific person as his agent to make decisions, to act on his behalf for his finance, for he or she's finances. So you'll see that when we have this person, the principal is designating this person as their agent, and as you see where it says grant of general authority, you'll see where it says grant of general authority. This the principal is pretty much granting the agent and any other successor agent the general authority to act for them with respect to the following subjects below. So the following subjects below can be to real estate, it can be to their personal property, it can be if they have stocks, bonds, commodities, options, whether they have a bank account, checking, savings, money market accounts, if they own a business, if they have any assurance or annuities, life insurance policies. You'll see the type of clients that set up these plans. They either will have a whole life policy or they will have a universal life policy. An index universal life policies, which you'll see. You'll see if they have any personal family maintenance, etc. Now, as a Georgia notary, when you're reviewing this, or if your signer is reviewing this, they have the option to initial which powers that they want to grant to their agent. They will initial the specific ones that they want to grant powers to. Now, if they want to grant all the subjects above, you only will need them to initial here where it says all preceding subjects. Typically in our signings, we'll see notaries will have the signer initial every single one of them, when the only thing they need to do is just initial here where it says all preceding subjects. So when you have them initial this area, this means that their principal is pretty much granting the agent to act on their behalf for all of these subjects above. So please do not have them initial every single one. If they have specific powers that they want to grant, then they would choose which ones are applicable. But if they want to grant all the powers above, only have them initial here. Okay, and that is for your power of attorney. And then for the second or third page of the power of attorney, you'll see you will see that the power of attorney will also get. They have the principal. The principal has the power to give their agent specific instructions in regards to their power of attorney. So that could be if they want to grant them the right to create or change rights of survivorship, create or change a beneficiary designation, etc. Typically, we will see the principals leave this page blank, but if they want to initial this page, they're more than welcome to do so. And this section is optional, which we see most principals or most signers typically leave this section blank. And again, you have a nomination of conservator, basically saying if the court appoints a conservator of their estate, if it becomes necessary for the court to appoint a conservator for the principal's estate, the principal can nominate a person for appointment, and you'll see that that person's name will be listed here. However, this is optional. If they don't, like I said, if they want to leave this page blank, by all means, they can do so. And then when we get to this page is where the power of attorney needs to be notarized. It's gonna have the principal's name here. So you want to get the principal signature. You want to have them dated. A question that I always get from notaries is, do they need to have the signer provide trustee verbiage? It's always going to depend on which attorney that you're working with. Typically, for most attorneys that I work with, they typically don't require the signers to print that trustee verbiage after their signature. But it's always a good thing to ask your clients just in case. You want to confirm that they have their address correct. You want to confirm that they have their telephone number correct. And if they have an email address, if they don't provide it, that's fine as well. And then this section does require a witness. So we need to get the witness signature. You want to get their name printed, and you want to get their address, their phone number, and email address if applicable. Now, I have a common theme with estate planning documents when it comes to witnesses. You always want to get the witness's signature, printed name, and you want to get an address as well. Again, you want to get the witness's signature, their printed name, and address. I can't tell you how many times we've gotten documents back. We can't tell you how many times we've gotten signed documents back from the notary, and the notary was able to get the witness signature, but they forgot to get their printed name and address. So always make sure you get that information so that way you have a flawless signing. And as a notary, you're going to do your part. You're going to get your signature and you're going to put the date your commission expires. This is something that we often see as notaries forget to print the date that their commission expires. Even though it may be listed on your stamp, you still want to have that printed on the document because that's what's listed on there. And where it says this document was prepared by, that will typically have the attorney's office or the law firm on this page. So that's how you complete the power of attorney. Next, we have the Advanced Healthcare Directive. Just to give you guys a heads up as well, these are not the full set. These are just the signature and notary pages, which is typically what you're going to see, because as a notary, it's not your job to explain the purpose of these documents. The attorney's office has already gone through this with the client already. So only thing you as a notary need to do is make sure this is that the appropriate documents are filled out correctly. So when it comes to the power of attorney for Georgia estate plans, you never want to leave these pages blank. You don't want to leave these pages blank. You always want to make sure these documents are signed and initialed. So for it says powers of healthcare agent after death. This is basically stating if the agent wants to have if the principal is giving the agent the power to authorize an autopsy of their body unless they have limited their healthcare agent's power by initialing below. So if they don't want if the principal doesn't want their healthcare agent to have the power to authorize an autopsy, they can initial here. If not, they can leave it blank. When we get to B, where it says organ donation and donation of body, if they want them to have the power to make a disposition for medical study, they can initial here. If they do not want them to have the power to do so, they will initial here. And if they do not want them to have the power to donate any of their organs, they will initial here. Now, if they're okay with it, then they can leave it blank. And also where it says final disposition of body, if they want their agent to have the power to make decisions about the final disposition of their body, then they would have initialed below. So where it says, I want the following person to make decisions about the final disposition of my body, the principal will initial here. The person who they're giving power is pretty much who's going to be their healthcare agent to make decisions on their behalf medically. That information is going to be provided here. And then where it says, I wish for my body to be buried or cremated, you must have the signer initial one of these options. Now, in the event that you're at the signing table and the client is unsure about what they should do, have them call the attorney's office. So that way that they get if they're a little bit unsure of what to choose, have them call the attorney, and then their attorney should be able to give them, inform them on what's the best choice or what's the best option for them. When we get to part 2 of the Advanced Healthcare Directive, we have the treatment preferences, and where it says conditions. Part 2 will be effective if I am in the following conditions. Pretty much where it says if they have a terminal condition, which means I have an incurable or an irreversible condition that will result in my death in a relatively short period. This is basically meaning if the signer isn't able, or if the principal isn't able to communicate their treatment preferences after reasonable and appropriate efforts have been made to communicate with them about those treatment preferences, then the agent will have the power to make those, will have the ability to make those preferences on the principal's behalf. So whether if they're in a terminal condition or if they're in a state of permanent unconsciousness, the signer would need to initial which one do they prefer in the event they're not able to communicate their wishes, and then their healthcare agent will make that preference on their behalf based on this healthcare directive. And then we get to this page as well, where we have options for A or B or C, basically saying if the signer wants to extend the life for as long as possible, they will initial here. If they want their natural death to occur, they can initial here. Or if they don't want any medications, machines, or other medical procedures that in a reasonable medical judgment could keep them alive, but cannot care for them, then they will initial here. So typically you're going to see the signers initial either A or B. But in the event that the initial C, then you want to go down to this section where they would need to initial either one of these options that make sense for them. So again, if you're looking at this, again, the advanced directive for this particular client, if you're Georgia notary watching this, try not to get overwhelmed. Try not to get overwhelmed by this. At the end of the day, you just want to make sure that again you're covering yourself by making sure you get this page initialed. In the event that they don't want to have to get the initial, in the event that they don't want to initial this page or unsure about what to print, again, you want to have them reach out to the attorney's office so that way they can get a more well-informed answer on how to proceed with this document. And then when we get to this section is optional, but we'll go over it. So this is guardianship. So again, in the event that if the principal wants to nominate a person to serve as guardian over them, in the event they can't make decisions. Sorry, guys. In the event that the signers, in the event that the signer wants to nominate someone as a guardian, in the event that the court has decided that the principal needs a guardian for whatever reason, they can either initial here, basically saying that they want someone to serve as their guardian, or the court will appoint one for them. So this one is optional. You can leave it up to the signer to fill this out. And then we have part 4, where it says effectiveness is signatures. This is basically saying that they're going to initial here, making this healthcare effective on or upon or whatever date that they choose, either here or they could choose there as well. And then this page will require a signature. So the declarant is going to be the person that's setting up the estate plan. It's going to require their signature. You'll date it as well. And then 2 witnesses are required for certain Georgia estate planning documents. And you want to get the witness's first name. You want to get their signature. You want to get their printed name, and you want to get their address. And you want to follow the same steps with the second witness as well. So always be sure, are you Georgia notaries? If you're going to perform an estate plan, always remember that 2 witnesses are required for the signing, because you're going to have a will, you're going to have the power of attorney, and you will have the advanced healthcare directive, which requires 2 witnesses. Always remember that. And then also, this may come with the power of attorney as well. This is the agent certification as to the validity of power of attorney and agent's authority. This is basically just certifying that the principal is alive and has not revoked their power of attorney or their authority to act or their authority to act under the power of attorney. And this also acknowledging that this power of attorney is effective immediately or on a particular date. So they're just certifying that. And the agent the agent would need to sign this document. Going to ask for their signature. They're going to date it. They have to provide an address, phone number, email address. You want it for you as the notary. They will sign in front of you on so-and-so date. Ask for a signature. The date your commission expires, very key. Make sure you always print and always put your stamp on this document. I've noticed too, side note, I've noticed here for our signings that we've had in Georgia, where we will have notaries that will put an embosser seal or some type of seal where it's not an ink seal, but it's been, I guess so here in California, we use ink stamps for pretty much all our documents. But I've noticed in states like Georgia, where we will have Georgia notaries that put like a seal but it's not inked. So when it's sent over in the scans, when we see them on our end, it looks like it hasn't been stamped. It just looks, but we have pretty much got to zoom all the way in to confirm that it's been stamped or sealed. Me personally, for us, we typically require notaries to provide an ink stamp because we have to submit these to the attorney's office. And I want to say pretty much 100% of attorneys that I've worked with, they always want to see an ink stamp. So if you have a seal, that's great, but I'm always going to recommend you use an ink stamp so to make sure to confirm that your documents, the client's documents, have been inked and signed. And then we have the certification of trust. Again, this is just a signature page. You want to make sure that this document has been signed. Trust, we have their signing as the trustee. Again, no trustee verbiage is required, just their signature. And if you as the notary, you have to do your part. So here in Georgia, you either have to select one of these options. Either you personally know the client or they produce identification. So if they produce identification, you want to put what type of identification did they present? Did they present a driver license? Did they present an ID? Did they present a U.S. passport? It has to be one of those options because we've literally had to have notaries go back out, or we've literally had to have notaries go back to the client's residence because this part was missed. So make sure you check this. Either check if you personally known them or they produce identification. If this section is marked, please make sure you print what type of identification did they present, U.S. notary, signature. Make sure you print your name because we oftentimes have notaries who do not print their name, even though it's listed here to say that their name has to be printed. Make sure you print your commission, and then you're going to stamp this document. Pretty easy. This will be the living trust document. So with the living trust, this is basically, it's typically about, I know here in California, it's typically about 50 to 60 pages. It's basically just acknowledging that they're setting up a living trust, who's going to be their beneficiaries, what properties do they have listed under the trust, what's the instructions for this trust, etc. You're going to get the principal's name. You're then going to follow the same steps. Either check personally known, or you're going to check off produced identification. You're going to type the identification was presented, your signature. You're going to print the date your commission expires, and then you're going to stamp this document. And we have the will. So we have the will. So for the will, if you're not familiar, the will is pretty much a document that's basically saying saying that whatever their wishes of their trust, they want that the will basically ensures that the wishes of the estate is being followed through. So this is how we're going to fill out this document. So where it says I have hereunto subscribe my name and affix my seal at, you're going to print this the city of where this document was being signed. So let's say for example this is taking place in Atlanta. You're going to print Atlanta here, and where it says seal, you're going to have this. They're going to have the principal provide their signature here, and then this section is where the two witnesses will sign. So I'm going to sound like a broken record, but who cares? I want to make sure all notaries that watching this video are very clear on how to fill this out correctly. You're going to have the both witnesses are going to provide a signature on the first line. You're going to have them print their name where it says next to witness, print their name. And you're going to have them print a mailing address underneath their printed name. Now they can use a P.O. box. They can use a P.O. box as well. As long as it's a mailing address, they can print that underneath their printed name. So again, we want to get a signature, printed name, and address. And this is how you perfectly execute this document. Please do not be the notary that does the signing and you only send us, when we get scans, you send us this document and it just only has the first witness's signature, printed name, and address. We've oftentimes have had notaries send us back documents with just only one witness signature. And when we ask them where was the second witness's signature, were they present, they say yes, but they still didn't get their signature, printed name, and address. Please do not be that. Please do not be that notary. Please verify that both witnesses are present. And if they are going to be present, please make sure you collect both of their signatures, printed name, and address. I can tell you right here and now, if you are a notary that's thorough and you make sure this page is signed, you are a notary that we're going to want to work with, and we will send you business. If you're a notary who does send this document back to us after completing a signing for us, and you only have the witnesses, only have one of the witnesses' signature, printed name, and address, I can guarantee you that we will not work with you again. Okay? So as long as we have an understanding, and that's how you complete the will. And with the will come a self-proving affidavit. This is something that we see, especially in Texas, Florida, and also Georgia as well. So let's go through how to complete this document. So where it says before me, the undersigned authority on this day personally appeared, we're going to have the principal's name. And where it has these blank lines, you're going to print the witness's name because you notice where it says blank and known to me to be the testator and the witnesses. The person who's setting up the estate plan, they are the testator, and the witnesses, you must print their names here. Or you can have the witnesses print their name here. You or the witnesses can do it. Either or works. Just make sure that the witnesses' names are here. We're then going to get the testator's signature. We're going to get their signature here. And here we're going to get the witnesses' signatures only. You do not have to print their name and print an address. I would recommend, I would, like I said, you can go ahead with just getting their signatures only. You don't need to have them print their name because their names is already printed here, and you don't need to get a mailing address. That's typically for the will. But for this particular document, you want to get the witness's name. We're going to get the testator's signature, and then we want to get both of the witnesses' signature here. And then when we get to the notarial section, again, we're going to have the testator's name, and then we want to make sure that you print the witnesses' names here. Once those witnesses' names are printed, you as a notary, signature, print the date your commission expires, and then you're going to stamp this document. And next we have the funding acknowledgement. This document doesn't need to be notarized, but this document is basically stating that they're acknowledging that they've been advised about the importance of funding their trust. So once they receive this document, it's been dated, you're going to collect their signature, then you're going to move on. Next, we have the assignment of personal property. Basically, this document is basically saying that they're giving their beneficiary the right to all the titles, interests, and all their tangible personal property. So that could be jewelry, clothes, furniture, silverware, photographs, etc. Once they acknowledge this document, they're then going to go ahead with signing the document. And then you, as a notary, need to check either they're personally known or produce identification, print what type of identification was produced. You then are going to provide a signature, print the date your commission expires, and then you're going to stamp this document as well. This is the HIPAA authorization. So basically with the HIPAA authorization, this is, let's say, for example, if I'm in the hospital, and my wife goes to the hospital and she wants to know what's my medical condition, because of HIPAA laws, the hospital will not give my wife that information unless they have a HIPAA authorization or a HIPAA waiver signed. Okay, so this is the purpose of this document. Meaning if the principal's in the hospital and his loved ones want to know what's going on with him, he has people listed on his estate plan, pretty much his agent, to let them know. And the hospital will inform the principal of his medical situation, what's going on with him. Once they sign this document, they'll know what to do. Check either or. Type ID was produced, signature, print the day your commission expires, and then you're going to stamp this document. Okay. So that's how you would notarize an estate plan documents for Georgia. What's really going to be important for you, honestly, is knowing how to fill these documents out correctly. As a notary, I wouldn't advise you to spend a whole bunch of time on knowing how to explain the purpose of these documents. And the reason being is because before the client ever sits down with you, or before they even schedule the signing, they have to review these documents with the attorney's office, and their attorney is typically going through page by page with the signer to inform them on what type of plan is being set up and what's the purpose of these documents. Now, once the signer has gone through these documents with their attorney and they receive a final draft of these documents and they approve it, then that's when they will proceed with getting a notary scheduled. So by the time the signer sits down with you, only thing you need, they've already, again, gone through all these documents with the attorney. So please don't spend a bunch of time or driving yourself crazy about explaining the purpose of these documents or knowing what they mean. What you should be mainly focused on is verifying that they have a valid and unexpired ID, driver license, or a passport. And if they do so, make sure they have all their documents available with you. And you need to ensure that the signature and notary pages are signed. Make sure you get the witnesses' printed name, get their address, get their signatures. Make sure that you get everything signed and completed correctly. And if you do it right and you provide excellent customer service, you will be an in-demand notary. So I hope you guys got a lot of, I hope you, Georgia Notaries, got a lot of value from this video. Again, we're starting to get more and more signings in Georgia, definitely in the Atlanta area. I think St. Mary's is another place in Georgia that we've gotten some business as well. We are on a platform called Closewise. So if you're a notary that wants to work with us, please do not email me. Please do not email me. We get bombarded with a lot of emails every day. Please make sure you join Closewise. And if we have a signing that's coming up in the area, and if you're on the platform, we will be reaching out to you to request your availability. And if you're a notary who doesn't miss any signatures, initials, dates, doesn't miss the witnesses' signatures, their printed name and address, and you're a professional and you treat our clients with respect, you're going to be a notary that's going to be in demand and someone that we want to work with. So we appreciate you. I appreciate you guys for watching this video today. Please let me know what your thoughts are. Was there anything I could do today was there anything I could have done today to make this a better video for you? I hope you guys got a lot of value from this. Again, make sure you like this video. Make sure you subscribe to our content for more, to get more notifications about content on estate planning and just notary in general. Appreciate you guys. Love you all. Peace.